Good morning, everyone. Thank you for joining the Profit Connect Wealth Services Investor Call. My name is Jeff Winkler. I am the court-appointed receiver for Profit Connect Wealth Services. Today is Tuesday, November 28th, 2023, 10 a.m. Pacific time. Want to just get started by reminding everybody about the timing of the events of this case and how things will go. As most of you know, initially we did a business evaluation. We've done a bunch of investigation, forensic accounting. We've been selling assets throughout the case. We did start a claims process, which the claims bar deadline was on November 11th of this year. September 11th of this year. And we hope to be filing the claims motion for approval and denial of claims by the end of this year. After that, we have some third-party litigation that's going on, which we will give you guys more information about, as well as taxes, distributions, and then, of course, then would be the closing of the case. So I'm going to go ahead and get started with the questions that you guys have provided to us, and so we can get those answered for you. The first question is, why does this process take so long? There are a number of reasons why this process takes a long time. Including the fact that this is a legal process and that there's a number of things that have to happen within the court system in order for this case to go from beginning to end. As part of that, we are working diligently to work through the different stages of this case and continue to move forward with that. Our hope is that this case won't continue on for years and years and years, but it's not uncommon for these cases to take between 3 and 5 years from beginning to end. The follow-up question to that is this case almost finished? The answer is no, it's not almost finished, but I do believe we're closer to the end than we are the beginning of the case. The next questions have to do with the defendants and other parties in the case. First question being, are there any criminal charges that will result from this situation? And the answer to that is we don't know. The U.S. Attorney's Office is the one who's responsible for prosecuting criminal claims. They are, of course, a separate entity from the SEC and from the court system. And so whether or not they choose to bring a case against the COVARs is completely up to them. I would encourage you, however, if you do believe that should happen, to reach out to the U.S. Attorney's Office in Las Vegas, Nevada, and talk with them about what happened and why you feel like that should happen. The next question is about justice being served with the defendants and the promoters of this case. Again, everybody's definition of justice might be different, but from a criminal perspective, again, that's up to the U.S. Attorney's Office. From a civil perspective, that is up to the SEC. But our goal is, of course, to recover as much money as was paid out to some of these individuals as is possible. Next question is, did HSBC protect their clients and will refund their clients' balance if they are going to be out after they receive what portion they're entitled to? Whether or not a bank decides to do that is up to each individual bank. I have not received any information that tells me that may or may not happen. If you have specific questions related to that, you could definitely reach out to your financial institution and ask them. Assets. What is the total amount collected from assets and investments? The total amount collected to date is just over $10 million. We do continue to sell some of the remaining properties that we have, and so that number will continue to increase. And we'll continue that process until all the properties have been sold. Claims questions. How can I get my investment back? So now that we have had the claims and we've had an opportunity to review them, we have a few final claims that we're going through the process of determining whether or not we think that they should be approved or denied. And then after we reconcile that, we will be filing a motion with the court with our recommended treatment of these claims. We do anticipate that we will be filing that motion sometime before the end of the year. And then investors will have an opportunity to be heard on that motion if they have any questions related to their claims. Investors should not be surprised by our recommended treatment, as we have been in contact with all investors. And if we believe that a claim should be denied, we've been working with that investor to help them understand why we think that and what documentation may help us change our mind on that. Ultimately, though, it will be up to the court and what the court decides. Next question is it too late to submit a claim against Profit Connect and its officers? The answer is yes and no. The claims bar deadline did come and go on September 11th of this year. However, if a claim is filed late, that will be up to the court as to whether or not it will be accepted. We will recommend denial of that claim due to the bar deadline that the court did impose, but ultimately it's up to the court to decide whether or not to allow that claim. How do we know if our claim was approved? There's a few different ways that can happen. First off, if you received a letter stating that you could sign the letter and then the claim would be allowed in a certain amount, if you sign that letter, then your claim is allowed in that amount unless you've been told otherwise. You will also receive correspondence from our office via email, telephone, or even postal mail. And those communications will give you an indication of how we intend to treat your claim. However, everybody will receive notice of the proposed treatment of their claim as part of the omnibus motion that we will file regarding the treatment of claims. If you have specific questions, you are welcome to email us or call us. I just ask that you give us some patience in responding to those, as we are still trying to work through the balance of these claims. We submitted our claims with information a few months ago. All we received was a claim number by email. Will there be confirmation that our information was received and verified? The answer, of course, is yes. You will receive information related to how we are going to be treating your claim. Chances are, if you've not heard from us at all, that means that your claim is probably either has not been fully audited, or that your claim will be accepted in the amount that you proposed. Otherwise, we would have reached out to you to work with you on that claim, unless you're one of the few handfuls of claims that we still have to work with. I gave cash to the promoter for the investment, but now I'm not able to qualify to receive my funds back because it is not tracked. What can I do now? So, in order for us to recommend approval of a claim, we have to have some proof that money was put in. And that can come in a couple different forms. It could come from receipts, copies of checks, copies of wire confirmations, or, if we know the amount of the amount that was invested in cash, and we can find a deposit that matches that investment, around the date that investment happened, then we can look at that and potentially use that to approve a claim. But if we have no documentation showing that the cash was ever deposited or received by the company, then unfortunately we will have to recommend that the claim be denied. Next question is about distributions and how long does this process take? So as I stated, at the end of this, by the end of this next month, we intend to file a motion with the court with the recommended treatment of claims. And along with that, we will be filing a motion for distribution. And what that is that lays out the way in which we intend to distribute the money out to investors. So typically the court will act on the motion regarding the treatment of claims and on the distribution at or near the same time. And once the court approves a distribution, then those checks will go out typically within 2 to 4 weeks at the most. Next question, when will we see the distribution of funds? Again, some of that has to do with the court and how long the process takes to get those motions heard and approved. My guess would be somewhere in the next, with the motions being filed at the end of December, my guess would be somewhere in the 60 to 90 days following that would be what I would expect to have the court hear and approve it. But some of that's going to have to do with whether or not there are any objections to either of those two processes. How's reimbursement being worked out? So the distribution process has not been finalized in this case, but typically in a receivership case like this, we would expect to do a pro rata distribution, meaning everybody who has an approved claim will get an equal percentage of their claim paid out based on the available funds. If somebody, what percentage of our money are we getting? Again, that number is yet to be determined because we don't yet have the final number on the amount of allowed claims. The percentage that you get will be the total amount of cash available divided by the total amount of approved claims, and that will be the percentage. Now, there are some future activities that will bring in some additional cash in addition to just the asset sales that we're working on, and I'll talk about those in a few minutes. Other distribution questions. If somebody invested $10,000 or more, should they get paid a higher percentage than somebody who invested $1,000? Typically in a receivership, we are working within a court of equity, and that means that the court wants to treat everybody as fair as possible. So under that scenario, typically we would expect that somebody who invested $1,000 and somebody who invested $10,000 will get the same percentage of their claim. The dollar amount will be different. So let's just say that we do a distribution that we figure is going to pay everybody 25% of their claim. Well, somebody who invested $1,000 and has an approved claim for $1,000 would get a $250 check. And somebody who has an approved claim for $10,000 would get a $2,500 check. Again, everybody's getting 25% of that initial payment. But do keep in mind that that is just a hypothetical, and as we don't yet know what that percentage of payout will be. When can I expect to receive some of my monies returned to me, and why is it taking so long? Everybody has the opportunity to be heard in this case, file a claim, and have their claim fairly adjudicated. And so that process does take some time. We want to make sure that everybody has an opportunity, like I said, to be heard and have their claim heard. We do, though, anticipate that that distribution will happen sometime either late first quarter of next year or early second quarter of next year. We will be filing, again, like I said, that distribution motion. We will send out an email at that time, with the proposed treatment of claims and with that proposed distribution order. Are we any closer to a final disposition and resolution? The answer is yes and no. We are getting closer because we are working through the timeline of events that we need to happen. However, there are some additional actions that we've taken that could potentially extend the case on the back end of it, and I'll talk about those in a minute. How will reimbursement happen if I'm living in a different country? If those issues do exist, we will work with the individual claimant. And it could be that we end up having to wire the funds as opposed to mailing a check. But we can work with you specifically. So if you are an investor who is in a different country, we will be reaching out to you prior to the distribution to make sure that we're able to get those funds to you. Many of us never received any interest on our investment. Will that be taken into consideration on the percentage of distribution? So typically in a receivership case, the general rule is that nobody will be paid interest on their investment until everybody receives their principal back. So the simple answer is no. Right now, nobody will be receiving any interest payments on their money because not everybody will have gotten back their principal. And so we need to make sure people get their principal back before any investments or interest can be paid. Keeping in mind, that this case, that there was no actual interest earned on this money, right? That there wasn't actual cryptocurrency, any significant cryptocurrency mining that occurred. And so there really weren't profits. Anything that was paid out as profits were false profits that were actually payments from other investors who had put money in that were paid out to earlier investors. How will claim payout amounts be determined? Now, ultimately, the distribution process is up to the court. We will make a recommendation on that. And again, typically, we're going to recommend what's called a pro rata distribution, meaning everybody's going to get the same percentage of their claim based on the amount of funds that are available. Will funds be returned in one lump sum, or will they be staggered? So once the distribution process has occurred, we will distribute out the amount of available funds that we have to distribute at that time. And then as we continue to collect additional funds, once there's an amount that is significant enough to make to justify being able to do another distribution, we will do a second distribution and even potentially a third distribution, depending on how that process plays out. Will the payments be paper checks or electronic? Typically in a receivership, these payments are made via paper check. We are exploring some of the different options available to us. But the default is typically going to be considered a paper check, but we will let you know if that changes. So recovery, how do I return payments made to me? Are there any other options if I don't have the full amount? So this is dealing with people that received either commissions or some type of bonuses for bringing people into Profit Connect. There are options available. The payments do get returned to our office. Care of the receivership, and if you need a payment plan, those are also available. I would encourage you to reach out to the person who contacted you or sent you the letter, and we'll be happy to talk with you about the available options. Next topic is third-party litigation. How many investors did their due diligence getting Bank of America confirm they knew about the business and transparency model as to protect our investments? Can these investors step in to provide testimony against Bank of America? And then the last question, which is similar, is what is the status of litigation with Bank of America? So we did get permission last quarter from the court to pursue a claim against Bank of America. The attorneys that were hired to do that work are in the investigation stage now. They have reached out to a number of investors and promoters and other people involved in Profit Connect, and they're putting together the complaint now. We do anticipate that complaint will be filed here very, very soon. And so, some investors will get contacted. If you have specific information that you think would be helpful to our case, I recommend that you either email us or call us and give us that information, and we may reach out to you to follow up on that as needed. There's also another additional third-party litigation claim that we got permission of the court this last quarter to pursue, and that was a claim against the attorney responsible, or the attorney who was representing Profit Connect, Dale Hayes Jr. And we have filed a complaint against him, and we are moving forward with that litigation as well. What if I have further questions after the conference call? The easiest way to get a hold of us is via email, and that's contact@profitconnect-receivership.com. That's contact@profitconnect-receivership.com. The other option is you can call us at area code 503-980-3711. That's 503-980-3711. If you have further questions that have not been answered, I would encourage you to either email us or call us. The other option as well is to go to our website, which is profitconnect-receivership.com. And that website has all the pertinent court filings and as well as other information about the case on it. I see that some of you have specific questions about what properties are being sold and when they're being sold. That information is all available on our website. Is there anything we can be doing now? The best thing to do would be to make sure that you've registered on the website, that we know who you are. If you filed a claim, then you don't need to necessarily register there because we already know who you are. But by registering there, that does ensure that you receive the emails that are sent out on a regular basis. And the other thing I recommend is that you get on the website and you check it out, on a regular basis to look at any new pleadings or things that may have popped up. We don't know whose spam filters may be filtering out certain emails, so I would recommend that you continually check there, especially as that it's especially if you know that there's stuff going on, like that we know that this claims and distribution motion are going to be filed in the next 30 to 45 days. So I would recommend checking to make sure that you have everything there. Will anybody be contacting us in the near future? The only reason we would reach out to you in the near future is, again, if we have issues with your claim or questions about your claim, or if the attorneys reach out to you to ask questions about Bank of America or any of the other litigation that we have ongoing. It is likely that there will be additional litigation in addition to what has already been filed, including litigation against certain promoters and other people involved in furthering this the Profit Connect scheme that was going on. So there will be some additional things that happen, and you'll be seeing those as they come up. It's very likely that, as I said, this case will go on for some time after this. But our plan is to distribute out, a significant amount of funds here in the next, 90 to 120 days, and then, there's potential for second and third distributions depending on the collection of money and the timing of that. So I encourage you guys to continue to be patient. I know that this process is a very long and painful process. We do our best to do things as quickly as we can, but unfortunately, to some degree, we have limited control over that. Litigation takes a long time. The court systems are backed up. However, we do anticipate that this will be a fairly significant source of recovery in this case, and so we've determined that it makes sense to do that. From a cost-benefit analysis, we think that this will be a significant portion of the assets that we can return. So I do see a question popped up in the chat. If a third-party claim against Bank of America or Attorney Dale Hayes happens, does that result in a class action suit? No. So when the receiver sues, that is not class action. The receiver is suing on behalf of the receivership estate, which of course then the funds that come into that then benefit the investors, and then those funds will be paid out through the receivership. Even if a class action had been filed prior to the receivership, in most instances or almost in every instance, the class action counsel works with the receivers counsel in order to come up with a settlement or to litigate the case in order to ensure that all investors see benefit of that case. And the banks are very unlikely, and the attorneys are very unlikely to want to settle with just the class if they know that the receiver is out there, because we would still have potential there. Another question popped up: are Brent and his mom going to jail? Again, we are working on the civil side of this case. The criminal side is is the U.S. Attorney's Office, and it's up to them whether or not to prosecute it. If you think that they should be prosecuted, I highly recommend that you reach out to the U.S. Attorney's Office in Las Vegas. If you call their general line, they will get you in contact with the U.S. Attorney who's responsible, for overseeing this type of a crime in Las Vegas. The next question is, are defendants out on bail? They have not been charged criminally with anything, so there is no bail. If they were to ever be charged, then that's up to the court as to whether or not to grant somebody bail and allow them out. Typically, in a white collar case like this, there would be bail, but again, that's up to the discretion of the court and the people involved in that. I wish I had more information about that, but unfortunately, I don't really have much more information on it. But if you do think that that's something important, then I would highly recommend that you do reach out to them and talk to the U.S. Attorney's Office and tell them why you think that they should be prosecuted. So those looks like all the questions that haven't been answered already. Let's see. Somebody has a question about interest. Talking about the money in, money out basis. So yeah, there will not be interest paid at least until everybody's received 100% of their investment back. And in a receivership case, that is not very common that they would receive 100% of their money, just because some of that money gets spent in ways that's not recoverable. However, as I said, we are litigating against third parties, and our hope is that the litigation will allow us to make a significant recovery for investors. Another comment here. See, back in the summer, you'd stated investors would be receiving close to 40% of their money back. Is that still the case? We do believe that by the end of this case, investors should see at least 40% of their money back. Based on the amount of funds that are available. That number will change a little bit over time, and it's going to depend some on the litigation with the banks and with the attorneys. If we're very successful in our litigation against financial institutions and the attorneys, then that number could be high, even significantly higher than that. But right now we cannot adjudicate that, and that's ultimately going to be up to a judge or a jury as to the responsibility of those parties. Or through a settlement with us. And so we don't yet know what that number looks like, but we are working towards that goal. But as I said, in the distribution process, we will be laying out how it is that we're going to go through and do this distribution. Let's see, how successful have the clawback recovery been? It's actually been pretty successful to this point. We continue to work with parties on clawing that back. There are a few people that we have worked with that are not being cooperative, and it's likely that we will be filing litigation against them. In fact, we will be filing a motion here very shortly with the court that allows us to pursue some of that litigation, because there are some people who got a significant amount of that money. And so we want to make sure we're getting that back so it can go back into the hands of investors. Let's see, a few other questions. When are we able to deduct the loss? That is a tax question that I unfortunately can't answer. What I would say is you should talk to a competent tax accountant. But typically a deduction can't be taken until you know what your loss is going to be. And so until you receive back all the money that you're going to get, it's going to be hard to figure out what that loss is. However, like I said, I would talk to a tax accountant or tax attorney and ask them about that, as they may have other ideas. Last question is, what is a clawback recovery? So clawback recovery is when people have received commissions for bringing people into this, or have received, what were stated to be interest payments or payments related to mining cryptocurrency. Since money was not actually earned in that way, that money is actually false profits, and so those are not actually interest or gains on that mining operation, and so those funds are expected to be returned back to the receivership. And so if they are not, then we will look to litigate where necessary and get those funds back. Again, we are trying to put everybody in the same position in this case and do the best we can. And that looks like that's all of our questions. Oh, how do we know if our claim had the necessary documentation? We will have reached out to you if we had questions about your claim. And so there will be an omnibus motion that's filed that will tell, that lays out the status of everyone's claim. If you have specific questions as to the amount or the approval of your claim, I would highly recommend you email us, and we can get you that information back as quickly as we can. Another question came in: what is the percentage of clawback recovery to date? I do not have that number in front of me, unfortunately, but that information will be reported in our quarterly reports, and so that is available on those quarterly reports are available on our website. That looks like all the questions for now. Oh, somebody popped up. Is Eddie Kona's estate part of the claim? We have looked at whether or not we have claims against Eddie Kona and what his estate looks like. Our understanding is that there isn't any real value in the estate, and therefore, filing litigation in order to pursue that would not be cost effective, as we would not recover what it would cost us to file it. And so at this point, we've made the decision not to pursue that. But if anybody has any information that would lead you to believe that perhaps there is additional assets there that we're not aware of, please do reach out to us and let us know. But that looks like all the questions for today. I appreciate you guys joining the call. Again, I encourage you, if you have questions, to reach out to us via email, via phone, or via website. All that information is still available in the chat, and all that information is also available on our website. Thank you all for joining, and I hope you have a great day.